Welcome to the 2022 Local and National Bankruptcy Rule Changes Seminar. This is Courtroom 5 South in the Eastern District of Missouri, and I'm Chief Judge Bonnie Claire. I'm here this morning with my colleagues,
Kathy Surratt States,
to present what's become an annual tradition in our court. Today we're going to start out with a review of new federal rules of civil procedure, move on to local rules, and then we're going to talk about changes in Chapter 13 policy and practice. We're glad you've joined us, and if you have any colleagues or anyone on your team who isn't online, there's enough time to reach out and ask them to get on so that they can hear about the important changes. We're looking forward to seeing all of you this morning virtually and hearing from you. If you have any questions, the Q&A box is open, and Matt Rodman from our team will be monitoring those questions so that we can answer them for you this morning live. At this point, we're going to turn the presentation over to our very own Clerk of Court, Dana McWay. Dana?
Hello, good day to everyone, and we're so glad that you're joining us today. As we just heard from Judge Claire, we are offering this seminar to you today as a continuing legal education, and this will be eligible for 1.8 CLE credits. After the seminar, either this afternoon or on Monday, we will be sending CLE certificates to attendees, and we will do the same for any of the rebroadcasts that we are going to do at the end of the month. So for those of you who are looking for CLE credit, be assured that you will be receiving those certificates in a timely fashion. As we mentioned, the chat function that you have here will be available to you for question and answer. We have built-in time to our agenda to have question and answer. So if you do find something that really isn't as clear or just picks up your interest for more discussion, please take advantage of that function for us. The materials that you will see on the screen are also available on the court's website and will be dropped into the chat function so that you can pull them up yourself. But we encourage you to go ahead and review all of the materials as you're going along, and then subsequently after the end of our seminar. So with that, let's go ahead and get started. We're going to talk first about our federal rules of bankruptcy procedure that are changing. I'm going to turn the mic over to Matthew Rodman, our attorney advisor, to speak to the set of rules that are first.
Perfect. Thank you, Dana, and good morning, everyone. We're going to start with the federal rules changes for December 1, 2022. A light year for changes on the federal level. And as you'll see in the materials that are posted to our website, I made an announcement in the Q&A chat section of where you can reference those materials. I also sent them attached to the email invite that you received for this meeting. I've separated the information into SBRA related changes and non-SBR related changes, as most of our changes are just conforming changes, making interim rules that came in when SBRA was passed permanent, with one additional new rule in light of SBRA. So you'll recall when SBRA was passed back in 2019, the rules didn't account for that. And so we needed some interim rules to be passed. So prior to the go live date for the Small Business Reorganization Act, we instituted some interim rules, and now they've gone through that rules enabling process and can become permanent. Previously, they were enacted in our district on an interim basis under General Order 20-1. Of note, once December 1, 2022 hits, we will in whole or in part, that's still being reviewed, be vacating that order as these rules will now become permanent. Going through some of the changes, of note, it makes, the SBRA has some differences from a general Chapter 11 case in that there is going to be a Subchapter 5 trustee. Disclosure statements aren't always necessarily going to be required unless a judge orders otherwise. And so that's a lot of what the types of things that these rules are going to cover. because these rules were already implemented on an interim basis and they haven't been changed substantively, I'm not going to go too deep into the weeds on any one. At the top of our information, there is a link to where you can go and look at those rules that are posted on the U.S. Court's website. However, I do want to highlight a little bit further down for us as part of bullet point number 11 there is a new rule that was implemented as part of this rules making process, specifically 3017.2. And this was implemented because there's generally not going to be a disclosure statement in a sub 5 case. So this rule is added to authorize the court in those sub 5 cases to act at a time other than when a disclosure statement is approved to set certain dates and times. Again, the full text of the rule is going to be accessed at that link at the top of the materials here today. With that, we're going to go to some of our non-SBRA related amendments, and I am going to turn it back over to the clerk.
All right, everybody. Let's talk a little bit about Rule 3002. This is filing a proof of claim or interest in a Chapter 7, 12, or 13 case or an involuntary 7. And basically what it's doing is it's taking out specific reasons for extensions of time from the federal rule. The idea being that the party, the movement, is responsible for identifying the reasons for an extension of time. And of course, that extension of time has to prove that whatever notice previously given or should have been given was insufficient under the circumstances so that the creditor could have reasonably filed a proof of claim in a timely fashion. So the rule is limited to 60 additional days. And the practice point here really is to think through about the fact that we have a CMECF event, and this is the event that you want to use for purposes of filing the claim. And you're going to want to specify not only that you're asking for this additional time, but why? What is the reasoning? Since the rule no longer grants those reasons on its face, that's now the movement's job. So you're going to identify that for us. And then if you want 60 days or maybe a lesser amount, you need to specify as measured from when. When is that 60-day window going to actually expire? When is that amount timed? So the event for CMECF is on your screen here, and it is those materials. This is, not as to the substance of whether you're going to be granted or not. It is really more geared towards the mechanics of how to ask for that additional time. I don't know if there are any practice points from our judges on this, or if we want to move on to the next rule. No? Okay. Very good then. Let's move to 5005. I'll ask Matthew Ritter to speak to this and to the next rule.
Hello, everyone. Again, my name is Matthew Ritter. Thank you for participating. I'll be talking about the rule change for 5005 as well as 7004. To begin with 5005, the groundwork for this change was laid last year in a change to a related rule in 9036, which allowed electronic noticing from the clerk's office to certain high volume recipients. This year's related rule change to 5005 concerns service, particularly electronic service, to the UST, and specifically allows electronic service upon UST via our CMECF system, which has been our practice in the Missouri Eastern District for some time. The subdivision B1 is amended, as you can see there, to authorize the clerk to use that electronic means in accordance with 9036. And then subdivision B2 is amended to recognize the parties meeting transmittal obligations to UST via that electronic service need not file a statement evincing that in pursuant to 5005 B2. Then for 7004, this concerns process and service in an adversary proceeding. The change makes explicit the permissibility of using titles when serving non-individuals, and is basically providing national consistency where formerly there was some isolated divergence. So again, you can see here in 7004, I has been added to reject the cases interpreting the Rule 7004B3 and 7004H that requires a specific naming of named officers or managing or general agents, other agents, rather than using titles. So again, where titles are now considered permissible.
All right.
Anything from our judges?
With regard to service of process on officers, let me add, it is not difficult to find out who you're looking for if you do want to put a name down. The SEC's Edgar website contains recent company filings available for free that will list who the applicable officer or officers are. They make it very easy for you to get that information. And the court does check service of process. Some of you I know have heard from my courtroom deputy advising just putting a company name down without directing whose service is to be to is not sufficient and will delay your adversary proceeding. Anything else? We're good.
All right, very good. Let's move on to Rule 8023. And this is about voluntary dismissals. And of course, all the parties may come together and they may have settled something on their matter. The rule is more of a conformance rule. The appellate rule in which it's modeled is very clear that fees that must be paid before the dismissal are court fees as opposed to attorney's fees. That had not been as clear in the bankruptcy rule. So now it's conformed to make it certain that the fees that are outstanding before dismissal can happen that must be paid are court fees. And again, this doesn't alter the legal requirements, of course, for separate approval of the actual settlement or the approval of the compromise or anything else that would have governed the payment or settlement of the controversy. That stands on its own. Merely dismissing this, saying, hey, I want to dismiss this case, doesn't mean that the settlement has been approved by the court. You do need to pursue that by a separate court order and subject that through the regular process. Any comments or questions from our judges? I think we're good. So what I would like to do now is have us transition to our local rules that have been changed. So let's turn the screen over to the local rules and turn this over to our judges.
All right, thank you, Dana. I think I am up first. We're going to talk about local rule 3010 first. That rule allows for small dividends or payments by our Chapter 7 trustees. This rule is just to be harmonious with the federal rules that require that there be some local rule or order so that the trustees can make the small dividend payments. All right, then the next rule, local rule I'm going to talk about is local rule 3015-6. This rule is allowing for suspension of monthly Chapter 13 plan payments. We've decided to continue with this waiver, with the suspension of payments. So under this rule, a debtor can now seek to suspend 3 consecutive monthly payments one time during their Chapter 13 case. This rule is very specific, though I would ask that those Chapter 13 practitioners be sure to take a good look at this. It requires that as well, if the motion is granted, if the debtor is subject to a wage order, it's the debtor's responsibility to cause the affected employer to stop the deductions of the monthly payments. The court nor the trustee are going to do those things. The other thing is that, as it says in 3015-6, Section C, the treatment of the suspended payment, it does not eliminate the payments. The payments would be added on to the end of the plan. And likewise, the suspension is without prejudice to the rights of any secured creditors who might seek to lift the automatic stay if they're being paid through the plan because they're not getting paid. And then finally, Section D of that rule tells us what the limitations are on this. This suspension is only for monthly plan payments. It cannot be used for tax refunds or other lump sum payments that need to be paid, and it cannot be used for payments that a debtor is making directly to a creditor. So when these motions are filed, If there is a response that is filed, then debtor's counsel should set that matter for hearing promptly, and we will take it up.
So let me see if I can make my co-panelists uncomfortable or the Chapter 13 trustee uncomfortable. Are you implicitly going to approve 63-month plans now?
No.
No,
Just want you to know I would have.
I do have one point to make on this particular rule, which is this is a one-time suspension situation. So think through with your clients very carefully when you want to use this. This is not going to be something that we will be granting multiple times. I am confident that someone will decide to test the situation, but I am not sure that is a test which you want to take. It is a one-time situation. We emphasize this. If it appears to the court that abuse is continuing, that abuse is occurring, then that may impact whether we leave this in place. The hope is that this will provide relief for those debtors who truly find themselves in exigent circumstances. But keep in mind, as we said, it is not a free pass. Other payments must be made, and it is the debtor's responsibility to speak with the employer. If the employer continues with a wage withholding during the period, that will not be grounds to come back in and say, ooh, we didn't mean it. So plan ahead, please.
Well, speaking of planning ahead, and given your response to my question, I wonder if the norm should be 57-month plans now. Because if you present a 60-month plan and you can't go beyond that, you're basically waiving this valuable opportunity.
Well, I think it is the hope that if the debtor waives those payments, that at some time, it would be earlier on in the plan, that sometime in the later months, they would be able to make those payments up, still within the 60-month period. And likewise, just to echo what Judge Claire said, I know that the trustee's office is always very good about informing us if this is a request that had been made multiple times. So I don't anticipate that we should have any problems with that.
I would make the point that we've been through what we hope will be the most trying time any of us have to experience, which was the 2020 COVID situation. And it is safe to say nowhere near a majority of Chapter 13 debtors took advantage of the suspension during that time. We anticipate this is something that only some debtors will use and that it is not going to be a routine occurrence. In addition, just so everyone is on alert, there is a case that made it up to the Supreme Court where cert was denied, but that the issue before the Supreme Court would have been, is the 60-month period jurisdictional? Cert was not granted in that case, but it might be. So keep that in mind as you plan.
All right, and then let's see, Mr. Rodman, if you move the practice point so that we can see, yes, there it is, the path for filing these motions. So there is something out there on CMECF for filing of that. All right, anything else then on Rule 3015-6?
No.
All right, thank you. All right, then the other rule I'm going to talk about is Local Rule 7004, summons. So when the summons is issued, the summons is good for 7 days following the issuance of the summons. What that means is you have 7 days to serve that summons. If something happens and you look up and, oh my gosh, it's the 10th day and you haven't served the summons, that summons is stale and cannot be served.
But by serving, you mean putting it in the U.S. mail?
Yes. So if your summons becomes stale or it comes back to you, return mail, oh, that's not really the right address anymore, then you need to request alias summons.
Alias is just another fancy word for saying the first summons was ineffective.
Correct. A second summons when the first summons was served unsuccessfully. So you should file a motion then to request an alias summons. And if by chance something happens to your alias summons and your alias summons isn't served properly, then you should request pluri summons, which is a substitute for the alias summons. if necessary, so that we have a good summons that's not stale, i.e. hasn't been around longer than 7 days before it is placed in the mail for service.
Well, we'll just finish the thought. Any fourth, fifth, or sixth request is also called a pluri summons.
Yes, it is, although we hope we won't get that far. So yes, so those are the things that we are looking for when the summons is not good and has become stale. And we are looking for you to file these motions, and we will grant them appropriately. They don't need to be set for hearing or anything like that. They'll be taken up in chambers, and we will get the summons, the alias or the pluri summons issued so that we can get service and move along with the case.
My prediction is that they'll be generally approved, any request for a pluris or alias summons. The norm will be approval.
Yes.
But there's another deadline we should remind you of, and that is on the back end. How long do you have to keep trying? The question is, well, you generally know who we're suing. The answer is, well, maybe you don't. In a student loan case, you may not know who the note holder is. So there's a Rule 4M of the federal rules provides that you must make service within 90 days of the filing of the complaint. If you fail to make service within 90 days and you don't provide an appropriate or acceptable reason, your case will be dismissed without prejudice.
Thank you. And then we also, in the practice points, there is a link where you can look to try to find your servicer so that we are sure that you are naming the right party in your adversary.
Our experience is that most of the time, this is not an issue. If an address turns out to be incorrect, that's easily remedied. But if you think there may be issues in service, it's worth putting the time in before you file the adversary to figure out where service needs to go. Also, we recommend knowing where you're going to try to serve your alias or pluri summons before you request it, because once you request it and it's been issued, the clock will start ticking.
The 7-day clock.
The 7-day clock will start ticking. And keep in mind, Chambers does monitor the time frame associated with those summons.
Yes, so 7 days for service, and then get your return of service on file with the court, and the adversary proceeding will proceed. Let's see, Judge Claire, I think you are up next.
I am. The first rule I'm going to talk about is new local rule 7041. This rule was introduced to provide a default procedure with regard to dismissal of adversary proceedings when cases are dismissed. And to be clear, by default, I don't mean taking a default judgment. That's the next rule. But this is what happens in the event of dismissal of the underlying case. Local Rule 7041 provides that 21 days after the dismissal of a bankruptcy case, the court will close any pending related adversary proceeding that has not already reached final judgment and where there's no appeal, unless someone in the matter files a motion seeking continuation of the adversary proceeding within that 21-day period.
And states the basis for jurisdiction, I would guess.
Right. There are situations where this court retains jurisdiction after the dismissal of the underlying bankruptcy case, but they are not universal and they are not automatic. So if you're requesting a case's dismissal, think through the implications. And if you want the adversary to stay open, plan ahead. The motion has to be filed within 20 days. This is being done for two reasons. One is to ensure that we are exercising jurisdiction appropriately in those matters. It provides an opportunity to bring the issue before the court. And the second is to clean up the docket, because we often have to deal with issues associated with an underlying case being dismissed, and yet there's an outstanding adversary proceeding. Anything to add?
Yes. The closing of an adversary, in my opinion, is not a big event, but the clerk has to have a conclusion to something that's been filed. But it's a ministerial act, and you can revive an adversary if you don't dismiss.
All right, let's move on to the next new local or amended local rule, which is Local Rule 7055. Local Rule 7055 deals with matters of default judgment in an adversary, meaning when the opposing party has not responded to a complaint. As most people know, we have an entire procedure that allows you to deal with this. And a plaintiff who wishes to receive a default judgment must first file a motion for entry of default by the clerk of court. Federal Rule of Bankruptcy Procedure 7055 sets out those requirements. And the first step is we need you to file a request for the clerk of court's entry for default and an affidavit supporting the entitlement to the entry of default. The change to the rule is we've deleted the requirement for a filing of Director's Form B2600 for entry of default. That is a requirement that was a holdover from the paper days. Now the electronic filing of the request for entry of default notifies the court appropriately of what's being sought. Let me note, default is a two-step process, so there are two affidavits you will file to get to a default judgment. The first is the affidavit set out in Local Rule 7055A2, the affidavit supporting entitlement to entry of default. That's an affidavit that should provide the court with information about when the adversary was filed, when it was served, when proof of service was filed, how service was made, and that no party has responded. This is different than the affidavit you will file after the entry of the clerk's default, after the clerk of court's entry of default in order to obtain your actual default judgment, which should provide the court with substantive allegations to support the entry of default judgment. For example, the debtor disposed of records and therefore the moving party is entitled for denial of the debtor's discharge.
I think this is significant because I don't think you should get a default judgment automatically. I think you need to present to the court sufficient affidavits or affidavit of entitlement to judgment. Lay out your case is what I'm suggesting.
Yes.
So keep in mind, first step, get your entry of default and file an appropriate affidavit. That should enable you to be on the path to actually get your default judgment at a later point.
And that just means no response has been filed and no clerk record shows an entry of appearance for the defendant.
The last local rule that I'll be speaking about is new local rule 9027, which deals with removal. We've put this rule in place because while the district court has a local rule with regard to removal, that district court's local rule doesn't really mesh with our ECF procedures or with how we handle removal here, which is more like an adversary proceeding. We've put this rule in place to give everybody guidelines. For those who are not familiar with removal, removal is a jurisdictional situation where an action is removed from the jurisdiction of another court, often a state court, but sometimes another federal court, and brought here.
And brought here, I think you mean to the bankruptcy court. I don't think you necessarily have to remove an action to the district court for it to get to the bankruptcy court. I think you can remove directly from state court to bankruptcy court.
Yes.
I will note, that is the procedure in the Eastern District of Missouri, but there are other courts where you must remove to the district court and then specifically request a referral to the bankruptcy court. So if you practice in other jurisdictions, check your rules. Now, note when you do a removal, you're dealing with not one court, but two. And your first step on a removal will have occurred before you even come here, which is filing your notice of removal with the state, filing a removal with your state or other federal court. Why? Because you will need to include proof of filing that with what you file with us.
Plus, you're informing the state court, I'm taking this case away from you. It's just a courtesy.
So if you wish to remove a matter to the bankruptcy court, you're effectively going to be commencing an adversary proceeding. As a result, you'll need to first pay the filing fee for a new adversary proceeding. Second, electronically file a notice of removal with our court. Next, file proof of filing the notice of removal with the clerk of the applicable court from which the action was removed, and proof of that service upon other parties, and a consent to entry of judgment form. That will also need to be served. So this is why it's important to first have filed your removal with the other court so that you can provide a copy of, say, a CaseNet record that shows first that you filed the notice of removal, and there should be a stamp along the side, and then to show proof of service of that notice of removal. And then a consent to entry of judgment form needs to be served upon all parties. Why? Because when you come to bankruptcy court, as in any adversary proceeding, jurisdiction is a primary inquiry.
Or stated simply, the right to contest the removal will be heard.
Exactly. You'll also need to file a completed adversary proceeding cover sheet and a corporate ownership statement containing the information described in Federal Rule of Bankruptcy Procedure 7007. I will note, when you do your adversary proceeding cover sheet, there will be a box to check that references removal. And you'll need to file a completed consent to entry of judgment form as the party removing. Let me note, the heavy lifting comes then at that point. You must file with our court a copy of the docket sheet from the prior action and a copy of all process, pleadings, orders, and other documents then on file in the other court.
But to be clear, filing the docket sheet of the state court is not sufficient. I heard and I agree with Judge Clare, you need to file with the bankruptcy clerk every piece of paper in the state court file.
While we're very grateful, for example, that the state of Missouri has a robust CaseNet system and that it provides us with all that information is not provided to our court automatically. And the state court is not able to electronically transmit those documents to us. As for example, when we put send the record to the bankruptcy appellate panel in an appeal. So it is the job of the party seeking removal to file all those documents in our matter. We appreciate that that's a lot of work and will take some time, but removal is not effective until that has occurred. This may take a lot of time, so if you know you're going to want to remove an action, prepare early.
Or alternatively, if you're the defendant and you know the bankruptcy case has been commenced, be ready to file your pleading saying we don't agree with removal, and we'll get to the next step, which is remand.
That's right. And one other note on dockets from the state court, documents from the state or other court, which is if in the rare event where there is an enormous number of documents, I'm thinking here perhaps of something involving multi-district litigation or a class action. If you want to do something other than file all the dockets, we will need, surprise, a motion that requests that so that we can address that issue. Now, there are certain things we need to see in a notice of removal. It does need to state whether the party filing the notice of removal, that's the party seeking the removal, does or does not consent to entry of final orders or judgments by the bankruptcy court. We need that so that we know how to process this matter. If the notice of removal doesn't have a consent to entry or a non-consent to entry, then the party removing the action has waived the right to contest the bankruptcy court's authority to enter final judgments or orders in the proceeding unless some subsequent order comes down. So just like in a regular adversary proceeding, you need to make it clear at the beginning whether you contest jurisdiction for entry of a final order here or not.
Think of removal as commencing a new matter in the bankruptcy court. You typically, when filing an adversary proceeding, you file this consent or not. And in removal, you do the same thing.
And then any party other than the party seeking removal who has filed a paper in the removed action will have 14 days after either filing of the notice of removal or in some rare cases, perfection of the removal in this court. And again, if the party doesn't file a notice of consent to entry of final orders, then that party will be deemed to have waived the right to contest this court's authority to enter final orders. It is the job of the party seeking removal to circulate that consent to entry of judgment to all parties in the case. We've already had a question, will ECF notice be given to the other parties of the filing of notice of removal? And the answer is obviously not, because those parties will not have entered in the action. ECF is only effective if someone has filed an entry. So it is the responsibility of the party seeking to remove to notify all parties to the removed action by paper service. We will look for a certificate of service on that, advising them of the removal and providing them with the notice of consent to entry of judgment. This is particularly important if you need some initial relief, such as a preliminary injunction, because service will have to be made for that to occur. As a practice point, we have included in the materials the filing path for the consent to entry of judgment and orders by the bankruptcy court, and we have modified our consent to entry of judgment form so that it can be provided as a freestanding form without a need for an additional issuance of summons in a case where the removed action was served prior to removal.
Okay, I think we've described the mechanical part of it. So let's get to something that is unpleasant, which is you can only remove an action to a court that has jurisdiction over that matter. And that would be the basis, for example, of an objection to removal. So we get into the sticky field of, does this bankruptcy court have jurisdiction over the matter pending in the state court? Want to talk about remand?
Sure. We can talk about remand. It is a question whether the action stays here or goes somewhere else.
Yeah, return to the state court.
Correct. So the party may come in, the opposing party may come in and file some objection to the removal, indicating that it is appropriate that the case be remanded back to this court where it came from, usually the state court. So we would take that matter up for hearing and hear the arguments and then make a determination. If we determine that it's going back, then we enter an order remanding the case back to the state court.
You just approach the abstention.
Yes.
Please.
So what if the bankruptcy court does have jurisdiction over the matter removed? There's still a hurdle called abstention, mandatory or permissive, where the bankruptcy court would determine whether it wants to hear the matter or not. And in Missouri, pardon me, in the 8th Circuit, the abstention factors are 12 in number, and I would urge you to look at the BAP decision on abstention, which just goes through the 12 factors, and you need to be prepared to defeat an abstention motion.
I would add, removal is an advanced maneuver, but it can be accomplished. You need to be prepared, though, going in to figure out how you're going to accomplish it procedurally and then to deal with those jurisdictional issues, which I think we all agree can get pretty thorny.
Yes.
With that, I'm going to turn the presentation over to Judge Shermer to discuss the next group of local rules.
So the final two rules start with 9050 proposed orders. And the only change in this local rule is reducing the number of days to make service of an order or opinion from 7 days to 2 days to 2 business days. There was no reason to wait 7 days. So it's 2 business days, and the prevailing party will, or the debtor in the Chapter 11 case, will make distribution of that order. Typically, if you are the prevailing party in a matter, court will say, or may say, please prepare an order consistent with my findings and conclusions, which I just recited. So there are 2 suggestions there. The first is you don't need to recite all of the findings and conclusions the trial judge made. All you have to do is say, based upon the findings and conclusions set forth on the record, and then give the conclusion. That's a practice tip. The second is, and I know you're probably tired of hearing me say this, circulate the order before you submit it. Everyone should have 24 hours to review it and suggest alternate language. If that cannot be resolved, then the objecting party can just submit this suggested words or phraseology, and the court will make a decision on the entry of that.
Judge Shermer, I don't think I'll ever be tired of hearing you say that.
No, because it relieves our staff of a big duty. The second and the last local rule is a quickie. It's negative notice. The only change there goes back to what Judge State said, including in the negative notice, the motion to suspend payments for the Chapter 13 case. And that's, I think, the conclusion of all of our local rule changes.
I think that's all. I'll just add again on negative notice. If you filed a motion on negative notice and the time has passed, please be sure to timely submit your certification and proposed order so that we can get that matter resolved and get the order entered. Sometimes there's some lag time between those things.
And not to be picky, but some of you like to change the language of the negative notice. So 2 comments. Your words are read, and it has to be in substantial compliance with 9061C.
My comment is, we know things have gotten more relaxed during the current circumstances, but you do need to have language that conforms with that language. If you delete half of it, then we have a problem in that notice isn't given to the other party, for example, about when an objection should be filed. And let me note, those of you who just put on your caption and write negative notice and an objection deadline, and you know who you are, that's not enough. Some of you may have had calls from our deputies saying, please, you need to use correct language. Let's just do it right the first time. We hate having to bug you.
Right.
All right. Let's go ahead, if we would, and let's revisit some of the official forms that are going to change. So we want to start off with Official Form 101, and that is shown on the screen. And you can see in paragraph 2, this is the form used for filing, of course, your petition for relief. And this has been amended so that we are clearly telling the parties who are filing what not to do, as opposed to only telling them what to do. We had some mistaken understanding by parties who were acting in good faith, who took the instruction that to identify all names they have used in the last 8 years to be far broader than what the courts were looking for. So we're asking for you to have your party, your debtor, talk about a maiden name or assumed name, a trade name, a doing business name of the individual debtor, as opposed to if there was some legal entity separate from the debtor, which the debtor may have been a shareholder of or some other operation of law, they are not listed. We don't want to inadvertently show that a party who has nothing to do with the bankruptcy is actually a bankrupt debtor because that party is listed in paragraph 2. We have our own Judge Kathy Surratt States to thank for this change. She, in her capacity as the chief, wrote to the Rules Committee and pointed out some examples of mistakes that debtors have made in the past. They listened and they made this change very promptly, and we are the benefit of it. So I think it won't be hard for everyone now that it's a little more clear. Let's move on to Official Form 309E and E2. And of course, this is the 341 meeting notice. The E1 is for individual debtors. E2 is for individuals who are filing or corporations filing under subchapter 5. So we are going to make it clear, and this is coming directly from the Rules Committee, that there are 2 deadlines here that we need to make certain that everyone understands. First, of course, is that we have a complaint to object to dischargeability of a debt. And we also have a complaint to object to discharge of a debt. So before, that wasn't clear that there were 2 different deadlines and that the parties had to meet those deadlines in order to file these complaints timely. The Rules Committee has broken those 2 out, made it very clear so that it'll be on the 341 meeting notice for all parties who receive the notice to know what their deadlines are. With that, I think I'm going to turn this over to Matthew Rodman to talk for a moment about the general orders.
I am here. Yeah, okay. So as I briefly mentioned, the general order making those interim rules for the SBRA that is going to need to be vacated as of December 1. That also gave us occasion to just remind everyone that the general order that had previously, due to the COVID-19 pandemic, that had allowed for a suspension of some of those deadlines with the UST's office for when a 341 meeting might occur, that general order has been vacated with the entering of General Order 22-1. The UST's office no longer needs that extended amount of time in which to make sure all those meetings are happening. And so we've gone ahead and cleaned up that order and gone ahead and vacated that as a court. So those two orders are just a couple updates of things that are to come or have recently came from the court in the area of general orders.
Very good. At this time in our program, we'd like to give a few moments to our Chapter 13 trustee, Diana Doherty. We have Diana coming in online, and if you're able to unmute, we'd ask you to speak for a few minutes, if you would, about some practice information for Chapter 13.
Can you hear me now?
Very good. We can hear you.
Okay, something in technology worked for me today. Yes.
Yay.
Hey. The court very nicely asked me to give some highlights of a recent seminar that my office put on. I'd like to give you a quick rundown of some filing trends that I have noticed in Eastern District of Missouri. Chapter 13 filings for my fiscal 2022 year, which ended in September, are up 18% from the Chapter 13 filings in fiscal 2021. This is good. To keep that in perspective, the total filings for 2021 of Chapter 13s were 1,797. For 2022, it was 2,113. To compare that to 2019, the last full pre-pandemic, those filings were 3,529. So even though the 2020 filings are up from 21, they are well below the pre-pandemic levels. Yesterday, the ABI put out some numbers showing that nationally, the October 2022 Chapter 13 filings were up 27% compared with October 2021. In the Eastern District of Missouri, that was a 16% increase. And it seems to me that we tend to run a little behind the national trends. So I'm hopeful that the 13 filings that we'll be seeing a pickup this coming year. With increase in filings, I think it's time to focus on some tips to streamline our practice. If you incorporate some of these options into your practice now, I think it could pay off for you when the filings increase and you have more cases to deal with. First up, court hearings. The shorter the court's Chapter 13 dockets are, I think the happier we're all going to be. The less time you have to spend at a docket or listening to a docket now, the more time you have to do other things. And when the dockets are shorter, I know certainly for my office, we can provide more attention to individual cases that are on the docket. So some tips to keep those dockets short. If you want to oppose an objection or a motion, file a response that describes your position and file that response well before the docket. If you choose to present your response at the podium, odds are that if I'm the party you're responding to, I'm going to say, well, I need a continuance because I need to look at this response. I need to consider it. I need to look at my file. And I think the court will give me that continuance if I ask for it because it's due process. I get a chance to analyze the response to my objection. So if you're going to be filing that, if you're going to have a response, file that response ahead of time. If you know you're going to need a continuance of a matter or you're fairly certain the matter is going to need to be continued, take advantage of the option to request a continuance ahead of time by sending an email to me. which then coordinates with the court. The procedures for that are set up on the website, and there's been some tweaks to that procedure from the way it used to be. Way in the past, you had to do it, I think, at least 2 days before. We looked at it once before the docket. Now we have the functionality in our email process has changed so that we can pretty much continuously monitor the requests for a continuance that come in by email. What that means is as soon as you know you're going to need a continuance well ahead of the docket, send in that request. If there is another party other than my office involved, you need to get their consent, you need to represent you have their consent, you should probably include them in the email. I may or may not agree to your continuance request. If I do agree to it, we will respond that the continuance has been accepted. We will include the courtroom or the appropriate courtroom deputy in that response, and the matter is continued. It's not going to get called on the docket. It's one less thing you're going to have to worry about on the docket day. And then, of course, if we don't consent, we'll let you know that as well, and we'll let you know why. Also, to help keep the docket short, if you know the solution to your situation is going to take longer than the next hearing that's 4 weeks out or whatever that may be, ask for a longer continuance. If it's going to take your client 3 months to get their tax refund in or whatever the issue may be, ask for a longer continuance. You may not get it, you might get it, but it will be less times that individual matter needs to show up on the docket. You can also try to avoid the need for a hearing altogether by filing a consent motion, a motion that will never need a hearing. There is a procedure on my website. You can find the link for the procedures to obtain the trustee's consent to a motion. Now, this is the consent you get before you file the motion so that you can file the motion as a consent motion. Obviously, you're going to need consent from all the relevant parties. So if I'm the only party, great. If there are a creditor or some other party whose consent is also required, you need to get that other party's consent first before you process the request through me. This is not just for motions for relief from the automatic stay. It can be used for other motions as well. So I'd suggest go to the website, become familiar with that procedure, and take advantage of these things to try to help shorten the number of items that need to be on any individual docket. Regarding the emails to my office about continuances or matters that are on a docket, do keep in mind that these Chapter 13 dockets have hundreds of matters on them. We are coordinating we are preparing for days. We are coordinating with the court a couple days out. Our dockets are printed very early on the afternoon, the day before the docket. The attorney will then go over the hard copy for a final review. The takeaway from this is that we have little or no time to check emails and coordinate those with the docket the day before the docket or even 2 days before the docket. So if you want to let us know something about that docket, don't do it at the last minute. You got to get that into us earlier. We just are not going to be able to get it hooked up with your matter on the docket. Another tip, we've heard about the option of a debtor getting suspension for payments now, but something else you can consider when a debtor is having payment problems is a stipulation with my office to resolve missed payments. There is a local rule that identifies a stipulation as a potential cure for a trustee's motion to dismiss. That's Rule 1017-2E. In that, for the stipulation, you would propose extra monthly payments that would cure the delinquency in 12 months or less. And there used to be a limitation that you could use that only on the first motion to dismiss. That limitation is no longer there. So there's a broader applicability of that. The stipulation will allow you to avoid a hearing on a motion to dismiss, and potentially you can even use it to avoid the filing of a motion to dismiss if you are aware your client is behind or early on, or you see something coming up. Now, keep in mind with stipulations, these are not binding on the creditor. It is an agreement between the debtor and the trustee's office that I will withdraw a motion to dismiss or refrain from filing a motion to dismiss if the debtor complies with the terms of the stipulation. That does not prevent a creditor who is negatively impacted by the lack of plan payments from filing any motion that they find appropriate. Although there's no official form for a stipulation, I either have or soon will have a suggested stipulation form on my website that you can use. It obviously hits all the things that I think are important. Another new option out there to help you, I hope, get cases across the finish line is if you are a debtor's attorney who has access to my website, there's a new report that you can run that will identify cases that are, okay, it escapes me now whether it's 6 or 9 months, short, I believe it's 9 months, short of completing. And by completing, I mean the plan duration, not payments. This is looking at the plan duration. So you can run the form, and it'll kind of give you a heads up on the people that you need to be in contact with. You want to be checking on feasibility, payments, tax returns, DSO statements, all those kinds of things that you're going to need to get this case across the finish line. And I'm sorry, I have not kept track of my time. How much time do I have left?
You're still good on time. You have a good 5 to 10 minutes if you need it.
All right. Then let's talk a little bit about payments. In Chapter 13, the real crux is getting those plan payments in. Plan payments don't come in, payments don't go out to creditors, everything falls apart. Times have changed. It used to be that we thought wage orders were the end-all and be-all, and wage orders can be a fabulous solution for many debtors, but I'm sure most debtors' attorneys are aware that there are some employers with whom wage orders are problematic. They don't start quickly, and some of them do not end quickly, and the money keeps coming out of the employee's paycheck long after the Chapter 13 has completed. So you need to be aware of who those creditors are, who those employers are, and consider whether wage order is the best option in that situation. U.S. mail can be problematic. We know that. It is what it is. Some people, I think many people, are more comfortable now with electronic payments than with paper payments. I know in my own personal life, I feel very put out when I have to write a paper check. I like doing it all electronically. I suspect many of the debtors are used to electronic payments and would prefer electronic payments. There are only 2 electronic payment options that I will accept, and those are ePay and TFS. ePay is very bare bones. It is the debtor going in and initiating an electronic payment from their account to my account. Each individual transaction has to be initiated. The debtor actually has to go in and do that and remember to do that. TFS has that option and also a number of other creative options. What they do, they do very well. They tend to keep a pulse on the market and try to come up with new products that are useful for different situations. So I would encourage you to become familiar with those options so that you know the range of options that are available. I believe the PowerPoint presentation that was given at my seminar is still up on my website, and you can look at that and determine what those options are. And I think the takeaway from all this is need to be aware of all the different payment options, all the pluses and minuses of those options, so that you can pick for your individual debtor what is going to work best. No debtor is the same. They're all individuals, and they all have different challenges. And I think with the range of options out there now, there are very, very good options for any individual debtor. You just need to know what they are and point them in the right direction. And also for the attorneys, with TFS, there are some, you can have your own login, and there are some options and reports, I think, that can assist you as well. The final point I'd like to bring up is uploads to my website. Since we're not meeting in person and getting to see each other, a lot of the documents you're giving me now are uploaded to the website. We've really broadened the scope of things that can be uploaded instead of mailed or faxed. I think it's great, but remember the basics of how this is going to work. Anything you upload to me has to be legible, and it has to contain the required information. Just because you have uploaded a PDF that says it is a pay advice or a proof of Social Security doesn't mean you've done it. It has to be that particular document, and it has to be a legible document. Also, it's quite helpful if the documents are uploaded as the correct type of document. If you upload pay advices as a tax return, when we go in to look for pay advices, we're not going to see any. We will eventually figure out what the document is, but perhaps not within the time frame that you need to have the case processed efficiently. So that was pretty much, that is my summary of what we did a couple weeks ago. And I will turn it back over to you, Dana.
Very good, and thank you for that. And again, as any of those who are watching have questions, there is a Q&A section that you can drop your questions into. For the moment, though, we want to turn it back over to Chief Judge Clare and Judge Kathy Surratt-States to speak about some logistics updates.
Thank you, Dana. Judge Clare, did you want to start off?
I'm happy to start off. So we're here to verify that the ugly rumor is true. Judge Schirmer is going to retire and leave us in a very Schirmerless bankruptcy world. I, for one, have never practiced bankruptcy in that world.
Nor myself.
So this is going to take change, and change is difficult for everyone. I think change will be difficult for Judge Schirmer because he will have no one to tell his Cardinals jokes to on a daily basis. And we will have change because for the first time in as far back as I can remember, really, Judge Schirmer will not be taking a Chapter 13 docket after January of 2023. So I guess this means I can finally throw away that tiny blue book of Judge Schirmer bankruptcy rules that I've been carting from employer to employer since the early 1990s. Is that accurate?
I'm keeping mine.
Are we framing them? Maybe we'll frame them or have some commemorative editions.
Maybe you'll sign them for us.
Oh, that's a really good idea.
Be good, you have an 8x10.
So Judge Schirmer is retiring, and as part of that, we'll be reallocating the Chapter 13 dockets. I am looking forward to taking on Chapter 13 dockets, and they will be, for at least the foreseeable future, divided between Judge Surratt-States and myself.
Yes.
What this means in terms of scheduling is, starting in January, there will not be 3 Chapter 13 dockets, but in most months, there will be 4 Chapter 13 dockets. Not every month. We do recognize the winter holidays. There are occasional scheduling issues, but most months there will be 4 Chapter 13 dockets, but they will continue and stay on Thursdays. What this means is that all Chapter 13 matters will be set for Thursday, with the exception of motions for relief from stay. Let me say it again. All Chapter 13 matters will be set on Thursdays, except for motions for relief from stay. So I know there are many matters Judge Surratt-States has been hearing on Mondays that relate to Chapter 13s. Those matters will now move to Thursday for all of the judges. In particular, if you have a motion to extend stay, you need to plan, because most months there will be 2 days allocated to you from the judge to which the case is assigned to have those heard. We don't anticipate issues because you know when you file your case that your client has previously filed. But do not wait until the last minute if you can avoid it. There will be, we know there will be occasional exceptions, but that will require special permission from the courtroom deputy in charge of the case. Like we said, motions for relief from stay in Chapter 13 can continue to be set on the judge's motion days, but everything else must be on Thursday. This is both for the court's convenience in terms of organizing and to assist the Chapter 13 trustee. Because we're adding another Thursday docket, we're trying to minimize the number of days that the trustee has to appear elsewhere, especially because on Mondays, which is Judge Surratt State's motion day, the Chapter 13 trustee's office is typically conducting 341 meetings.
Correct. So that's the change for me. Normally, in addition to hearing motions for relief from stay on my Monday motion docket, I also hear the motions to extend the automatic stay, but those should now be set on my confirmation docket dates.
So we plan to continue each having 2 dockets on our regular Thursday days. I am redubbing mine the early and the late, and I plan on sitting at 9 and 10 for the early and the late dockets. What about you, Judge Surratt States?
My dockets will remain at 10 o'clock and 11 o'clock.
Now, we are letting people know there will be some reallocation of who is on the early and who is on the late docket. Parties who are moving will be notified separately offline by the Chapter 13 trustee. But we worked very hard in considering who should move. And what we want to make everybody aware is that moves are a result of continued good practice and good practices by those attorneys. People who adhere to the continuance procedure, people whose dockets are prepared, and cases that generally run smoothly. The point is on the early docket to move through a tremendous volume of matters very quickly.
That is correct. Yeah, in some cases, as we know, some practitioners tend to handle cases that are more difficult and not the run-of-the-mill average case that has a standard trustee objection that can easily be resolved as well. And that's what we're looking for on the early docket.
And what we want to assure all of our practitioners is we value your time and your work. We put a lot of time into consideration of allocating the dockets. We'll be re-examining these issues next year, and continued superior performance, and in particular, adherence to the continuance procedures the trustee has just accepted, will be taken into account in determining what to do. This brings us to the next question we've had from a lot of people, which is, when are we going to go live? Or even Judge Surratt States, are we ever going to go live?
Oh, we are coming back to court at some point. It is difficult at this point, even though the COVID-19 pandemic is more under control than it has been in the past, but we do still know COVID is still out there, and occasionally we hear from some lawyers who, tell our courtroom deputies, oh, I was going to appear in person, but I was exposed over the weekend to someone and I'm not comfortable coming down to the court. So we continue to take that into consideration, and we'll continue to assess and determine when we will have court with everyone coming back into the courtroom.
Let me know. In terms of when we go live, we don't know that answer, but the judges have been assured by Director Moskoff, who is Judge Rosalind Moskoff from out east and the head of the Federal Judicial Conference. I'm sorry, that's the wrong
Administrative
head.
Office.
The head of the Administrative Office of U.S. Courts, that we have these courtrooms and we will be using them. We are only able to do the virtual hearings we do as a result of an emergency authorization that was put into place. And at some point, that may, and we expect will, come to an end. However, requests are being made by the bankruptcy judges to allow us to do certain matters virtually. But what I want to assure all of you is this is not a decision that we get to make at our level. Whether the emergency authorization stays in place or not will be made well above our pay grade. Until then, though, we ask that you give consideration if you are participating virtually. And we encourage you, even though you're not coming to the courtroom, to consider what you would be doing if you were practicing live. We know a lot of work typically gets done right before a live docket where parties manage to settle or resolve things. And we would ask that you reach out to each other well in advance, because that's one of the things that will help streamline the dockets.
Now remind everyone, as we do every docket, your phone should remain on mute unless you are talking. And likewise, I'll remind everyone to continue to announce yourself. We know most people's voices, but we want to have an accurate record. So please identify yourself before speaking.
And I know those of you who've been on my Hannibal 13 dockets know, if I know you're planning to appear virtually, I will call for you during your matters. However, I don't know to call for you during your matters if you don't advise my deputy in advance that you're calling in. So I will be taking on Judge Shermer's courtroom deputy, Jennifer Haven, and you can continue to let her know that you will appear virtually. That way I know when I call your confirmation matter to ask for you and to see if you're there or not. I also do wish to let parties know that in organizing my docket, I will be adhering to what we've been calling the Judge Surratt States protocol. So in terms of how things will be put on the docket, we will continue Judge Surratt States practice of having the confirmation dockets consist of matters that are only confirmation before the court that day.
So yeah, my docket consists of, first I have any motions, Department of Revenue motions, and trustee motions to dismiss. And if there is a confirmation along with that, that's heard first. And then I hear all the matters that are just set for confirmation.
So again, I'll emphasize, if you don't want to sit through the docket and you know, for example, that you filed an amended plan and we will not be at 21 days, please use the trustee's confirmation procedure. Then you don't have to sit through the docket. I'm looking forward to seeing all of you. I think some of the practitioners know I spent a tremendous quantity of time, particularly in the late 90s and early 2000s in the Chapter 13 docket. So I'm really looking forward to doing that work again. Judge Surratt States, do you have anything else to add?
I do not.
Judge Shermer, anything to add on Chapter 13 logistics?
Yes, one practice point. If you have a case that's going to be transferred from me to Judge Claire, and you have a matter heard by her, she gives you a ruling, try to avoid saying, okay, but that's not how Judge Shermer did it.
We will put a statute of limitations on that remark into effect.
Yeah, that's not fair. After he's retired, then we have to bother him while he's hanging out, on the beach or something, asking him, is that what you really did?
He will be very unhappy if I call him while he's in his first pina colada of the afternoon.
I'm not going to go there.
Judges, we did receive one question in the Q&A, and that was regarding whether the Chapter 13 dockets in Cape Girardeau would move to Thursdays as well.
Oh, good question.
I can
Go ahead.
Do you want to? So we have, the 8th Circuit has selected a successor to Judge Shermer who has put together a preliminary calendar. And as things stand, my understanding is the Cape Girardeau dockets will not be moving from Mondays, at least not for next year. I think we're going to see how the first year goes in terms of scheduling, and then it is possible that Judge Shermer's successor may move them, but at this point things will stay on Mondays. And Judge Surratt States, we can tell you, will be taking over Hannibal. Yes. Judge Surratt States, what are your plans for Hannibal, the courtroom that time has forgotten?
Oh, to continue the motion to have the Hannibal dockets heard on Thursdays, usually the 3rd or 4th Thursday of the month.
I've let Judge Surratt States know all the spots to watch for water leaks up in Hannibal. If we do have any other questions, we're happy to take them in the chat. We do want to hear from you. We work with the Chapter 13 Trustees Office to put together procedures for next year. I do want to make clear I will not be doing the Judge Shermer pre-docket that has been used for the past period of time. I'm going to try to adhere to the Surratt States Protocol and continue to encourage everyone to do the Chapter 13 trustees continuance procedure. If the filings go up as much as many people think and hope, then we may have to examine other alternatives to get through the docket promptly. But really, what's on the docket is determined by the practitioners. You all are a valuable part of the process, and your work to get matters taken care of, settled, continued is really appreciated. In the rare event when you do have a matter where you know you're going to put a witness or even witnesses on, please reach out to our Chapter 13 deputies in advance so that we can make an arrangement for you, so that you're not feeling pushed in the middle of a docket when you really need, say, 30 minutes to put on evidence.
Oh, yes, definitely. If there's a Chapter 13 matter where you're going to need evidence, that would be set at a special time, not at the standard Chapter 13 dockets.
Did have a couple more entries in the Q&A. The first one of our practitioners would like to let Judge Shermer know that he will be missed, and I think we can all echo that 100 times over.
Thank you.
And the second one was the second question was directed to Judge Claire, and the question was, what was the website that you had mentioned that listed titles of officers and etc. for service purposes?
So you can go to www.secsamanthaedwardcharlotte.gov, and you're looking for Edgar, EDGAR. The Edgar is the online repository of mandatory documents that public companies have to file. Edgar is free, and you can search by company name. There will be numerous reports listed. And you can look for reports that indicate the names of officers. For example, if you look at a 10K, which is a periodic report that gets filed, usually on the cover or in the first couple pages after the cover, it will list the officers of national companies. If you're dealing with a local entity, of course, you can go to the Missouri Secretary of State's website. And again, for free, look at the corporate filings in that case to see who the officers are. It will usually list their addresses as well. And like I said, again, free, which is a bankruptcy lawyer's favorite price.
I think we may have exhausted the questions in Q&A. Certainly, if anybody has something, please add. But if you would, our judges have any closing remarks before we end?
Nothing?
Not today.
You know, this is Judge Shermer's last local rules seminar. We have asked him if he would come back next year to join us, and I think his answer was a resounding, oh no. But we do appreciate all of his work and service and attention on these rules. I know when I was a young practitioner, he schooled me and encouraged me to live right.
Yes. Yes, Judge Shermer, you will be missed, and we may call on you sometime. Please don't turn your cell phone off when we call. All right, Dana, I don't think there's anything else. I guess other than, of course, I always like to remind the practitioners, I think a lot of them know that, you know, the clerk's office is there to help you. Our courtroom deputies are always glad to assist you, take any questions, bring any matters before the judge that they think that they need our assistance on. Matthew Ritter is our operations manager. He is always open to take telephone calls and assist people. And likewise, Matt Rodman, as the attorney advisor, is always available as well. As you can see from today, he's kind of our local rules guy and helps head up the local rules committee as well. So feel free to reach out to any of them. And of course, Dana's always available as well. If there's questions or comments or things that we can help you with.
And let me add, to some degree, the local rules are the practitioner's local rules. We have a local rules committee. They work together early each year to look at the local rules and determine whether there are any issues or changes that need to be addressed. If there are rules that you think need revision, or rules where you have questions, or a rule that you think should be added, please feel free to reach out either to Matt Rodman or to the members of the committee. I believe they're posted on the website, and have them pass on that input. We are very amenable to receiving changes to the local rules. Many of our local rules changes come from practitioners who say, hey, what about this issue? The comments are most appreciated when they come with some proposed language or remedy a specific problem. And the process is then that the committee discusses the changes and recommends changes to the judges. The judges review those changes, and then proposed changes are circulated to the public. We receive very few comments each year, so when you receive those emails from the clerk, please do take a few minutes to look them over and provide us with your feedback. We do take feedback into account, and even this year we made a change to one of the proposed rules because of a comment from a practitioner. After we approve the rules, we send them to the district court, which reviews and approves them, and then the 8th Circuit Court of Appeals, which reviews and approves them, hopefully each year in time for them to go into effect on December 1. Preview, there is a major revision of the federal rules of bankruptcy procedure coming, primarily a stylistic change. And when that comes, there will be a lot for all of us to learn about. We're looking forward to that and going through the process with you. And as always, we appreciate you and your work and your clients and your participation in the judicial process. Dana?
Very good then. I think we have done a great job, and we appreciate all of the people who have given us questions, who have listened attentively, who have participated with us. We thank all of the presenters who gave their time and effort and energy to make sure this was a success. For those of you who have registered, we will be sending you those CLE certificates. We will be posting this video later in time on the court's website, but in the meantime, we will rebroadcast it, and we will offer the opportunity for monitoring so that you can qualify for CLE credit. Those dates are at the end of November, and they are on our website. If you, a member of your team, someone that you know who did not attend, would benefit from that, please spread the word, let them know, because we want to reach as many people as we possibly can. It's our effort to make certain that practitioners know what the rules are so that everyone can play in a fair manner. And this really helps to do so by giving everybody the opportunity to be part of a seminar. With that, I want to thank everyone for attending. Thank again everyone who presented, and enjoy the rest of your day. We hope that it goes well, and we are pleased that you are part of our day with us. Thank you.